Good morning, everyone, and welcome to Audit-Proof Your I-9s, hands-on training for compliance success webinars. You may find it helpful to have a copy of an I-9 in front of you as we're going through today's presentation, but if you don't worry, because we do have visuals that will be on the screen throughout the course of the presentation itself. My name's Tawny Alvarez, and I'm a partner in Verrill's Labor and Employment Practice Group, and I'm excited to be joined today by my colleague Emily Waddell, also in the Labor and Employment Group. Today, we're going to be discussing how to conduct internal I-9 audits. We're going to review the documents that Immigration and Customs Enforcement, or ICE, will look at during inspections, and also discuss best practices that employers need to take when completing I-9 forms, and then also how to audit those practices to make sure historically if they have done the correct thing. A couple of notes before we get started. For those of you who are not familiar with Verrill's webinar series, it will be recorded, and an email of the recording as well as the slides will be provided to you in the coming days. Additionally, this webinar has been approved for 1 SHRM credit and 1 CLE credit. If you are an attorney, you'll be submitting your name to the main bar for CLE credits. And if you are seeking SHRM credits, you will get an email of the certificate of attendance for your records. If during the course of the presentation you have any questions, please use the Q&A box, and we will do our best to answer those questions in real time as we go through the presentation. And with that, let's get started. So if you have attended our webinar series before, you know that I think it's really important that we start off with our goals for the presentation. So that if you're sitting here and in that first few minutes, you say, wait, none of these goals are things that I care about, you can jump off, right? I also don't want you to get to the end of the presentation and say to yourself, gosh, Tawny and Emily didn't talk about X, Y, and Z, and I thought they were going to. Our goal is to really set forth generally what you can expect from us during the course of this presentation. First, we're going to set forth what the current landscape looks like. Why are we having this conversation now, and why might there be a heightened interest in this topic at this time? Second, we're going to talk about the difference between a notice of inspection and what's referred to as an ICE raid. With regard to both a notice of inspection and an ICE raid, we're going to help you understand what the risks are as it relates to the two different scenarios. We're then going to go through step by step how to complete a Form I-9 to minimize fines and decrease the likelihood of employing undocumented employees. Finally, we're going to talk about the I-9 audit process itself so that you can preemptively review documents and decrease risk as it relates to, you're sitting here, you're hearing how to appropriately complete the I-9 process, and you realize, wait a second, we haven't been doing that. I've never done that before. Let's talk about how you can go back, audit your practices, and still decrease some of the risk associated with those previous issues more generally. Let's jump to the current landscape. So as many of you may be aware, there's been a number of executive orders in the last few weeks. One of them is the birthright citizenship order. This is prospective in nature, applying to people who are born after February 19th of 2025. And what the executive order attempts to do is restrict any state, local, or federal government from issuing documentation recognizing citizenship to any person whose mother was unlawfully present in the United States, whose father is not a U.S. citizen at the time of the child's birth, or whose mother was lawfully temporarily in the United States, but whose father is not a U.S. citizen or lawful permanent resident at the time of birth. Now, while this executive order was set to take effect on February 19th, it has been enjoined by a number of different courts. So an injunction is currently in place, and there's at least 3 cases that have been consolidated into multiple additional ones that are reviewing this issue to determine the constitutionality of the proposed birthright citizenship order. Let's jump to another executive order that has also playing a role in this discussion. That is protecting the United States from foreign terrorists and other national security and public safety threats. What this executive order does is it directs the Secretary of State to work with Homeland Security and the Director of National Intelligence to identify ways to screen and vet individuals who are seeking admissions to the United States or who are already in the United States to the maximum extent possible to both verify identity and create uniform baselines for screening and vetting. So, Emily, what does this current landscape mean for employers? Let's jump to the next slide.
Yeah, thank you, Tawny. So, with the current landscape, employers are in a unique position. We are expecting to see more enforcement activity from ICE and DHS, Department of Homeland Security. While DHS does have authority and ICE does have authority to look for individuals they suspect of not having valid documents or citizenship documents in public or at their home, it can be more effective for these agencies to go to the workplace. Employers perhaps will see more activity in this area than they have before. Um, you know, this could be through, what we're hearing a lot of on the news, like ICE raids, and Tawny's going to go into that in just a second. This can also be through I-9 notices of inspection, which we're going to talk about a little bit later in this presentation. And how that would kind of work is, if an I-9 notice of inspection was conducted, perhaps ICE or DHS could find discrepancies either in how paperwork was completed or in the documents that were used to verify identity and work authorization. And that could possibly trigger, maybe an ICE raid or other activity from these agencies that employers would then have to respond to, depending on the findings of the audit. We are going to focus on both ICE raids and I-9 notices of inspection. So on the next slide, I will talk about just quickly level setting us with the difference between these two actions. So an I-9 notice of inspection is sent to the employer by DHS or ICE, and the document will request to review company I-9 documents, which are completed at the start of employment. And the purpose of that audit is to ensure that A, the document is completed correctly, and B, that the documents that were relied upon in completing that form were valid. These types of inspections are usually given, they're required to be given with at least 3 days notice. And we'll talk about what that notification process looks like and kind of the steps that you have to take as the employer to prepare for that audit. And this is different, obviously, than an ICE raid. ICE raids are unannounced. Immigration enforcement officials arrive at a home or a place of employment or a public area, and the intent of that raid is to locate, detain, and deport individuals suspected of violating U.S. immigration laws. So with that background, Tawny is going to dive into ICE raids.
So the reason why we're kind of level setting here is so that we understand when a notice of inspection occurs, what the difference is between an ICE raid and a notice of inspection. If an ICE raid were to occur, you would likely see one of these three documents. So an individual from ICE would arrive at your location, come to the front door or a public space within your organization, and hand you a subpoena, a judicial warrant, or administrative warrant. So on the left-hand side, you're seeing an administrative subpoena. If an administrative subpoena were to be what brought the individual ICE agent to your organization, what it's going to do is it's going to identify either that there's documents that they're seeking or that they're looking for an individual kind of specifically, right? And it'll identify those records. In this situation, the ICE agent does not have the authority or ability to walk throughout the private space of your organization. They must stay in the public space. However, if your public space is not identified, if your public space doesn't identify what space is private, there's no limitations for an ICE agent kind of walking in, looking around, doing those things as they're attempting to serve that subpoena. Now, if we are in receipt of a judicial warrant, which is the central piece of paper, the one that does not say sample on it, but says United States District Court, this is a judicial warrant. A judicial warrant is going to allow the ICE agent to go anywhere within your organization in an attempt to arrest someone who they believe is undocumented. So if an ICE agent were to arrive at your location, you certainly should engage in your ICE protocol if you have one, and we're going to discuss that momentarily. But you have very limited kind of, I don't want to say rights, but you cannot object to them coming in. They can go into private spaces, they can go into public spaces seeking the individual identified there. So this is a judicial warrant. And then if we go all the way to the right-hand side, this is an administrative warrant. An administrative warrant is very similar to a subpoena, where the individual, the ICE agent, can stay in public spaces within your organization, but you can refuse to allow access to private spaces. Now, with both a subpoena or with a administrative warrant, you can choose if you'd like to allow them to have access to your whole organization, public space, private space. That's an individualized employer determination and decision. It is one, however, that we recommend that you talk about with your senior leadership and come to a conclusion, because you're not going to have time to make that decision in real time when ICE is standing there. You're either going to have to say, yes, you have access to our space, or no, we'll only allow you to have access to our public space. Let's jump to the next slide. So I said earlier, kind of, it's important to have these discussions beforehand. A lot of employers have been reaching out recently to us to discuss, hey, what things should we do to prepare and understand what an ICE raid would look like? The first thing is something that I've now repeated a couple times: identify your public and your private spaces and use signage or other security processes to specifically identify that private space, whether or not it's signage, whether or not it's swipe cards, whether or not it's keys. Anything along those lines should be used kind of for private spaces. Next, we have a document, and you're welcome to reach out to either Emily or I, and we're happy to provide it, which is how to respond to U.S. immigration and custom enforcement raids. Having a copy of that document, or a document that you've internally created for your organization at different points of entry with specific points of contact, is important, because oftentimes when an administrative official arrives at an organization, the person who is at front of line is caught off guard and is nervous, and having a document to refer to as to what the standard operating procedures are in this situation is very helpful. Next, prepare and train your team. So identify a coordinator, identify a second in command, a first contact employee, someone who is going to be responsible for engaging and interacting with the administrative officer more generally. We oftentimes recommend that this should be a manager, somebody who has authority to bind the organization, and that prior to this, we've set forth for our employees who may not be managers what their expectations should be for kind of a situation such as this. And then you should also prepare an ICE visit policy. So another standard operating procedure that sets forth, this is who we call, this is what we consider private and public space. Here are what the documents that you could see look like and what we expect you to do. Here's when we call counsel. You know, we do recommend that counsel be somewhere on that list of people who are called, especially if there's any question as to whether what you're looking for is a legitimate judicial warrant, or if you're looking at an administrative warrant or an administrative subpoena. We had a question, which is if employees use access cards and to get into private spaces, so everyone has access to public spaces, but employees have access cards to get into private spaces. What happens if an ICE agent tailgates the employee when they're walking into private space? you've now allowed access. And that's why it's important to have training for all of your employees. And that's both from a security of your organization more generally, as well as from an ICE perspective. So as soon as any of your employees, management or not, allows access to private space, they have access to that private space and you cannot later object. So making sure that you have employees trained, only employees, only staff are allowed beyond this point unless, X, Y, and Z has occurred. Those are really important conversations to have, not just with your management team, but with all employees. Let's jump to that next slide. After a raid or during the raid itself, and we do have other documentation, again, reach out to Emily or I, and we're happy to provide you with these materials. But how do you respond to a U.S. Immigration and Customs Enforcement raid? Contact counsel, document all of the interactions. So ask any employees who are there to provide written statements. If ICE has requested documents and you've provided documents to them, make sure we have a copy so we know what's been provided. If they have a judicial subpoena, we want to make sure that, a judicial warrant, we want to make sure that our team members step back and allow them to do what they need to do as to that warrant. But we should absolutely be watching where they're going, taking notes as to who they're seeking. You can have someone who kind of follows and keeps track of what's happening. They should not interfere in any way with that, right? And they need to follow the directions more generally, but you do have the right to see where they're going, what they're looking at, all those things. And after the situation, they should write extensive notes about what they saw and what they did. If an employee of yours is removed during the raid, you should immediately ask the ICE agent, where are you taking this individual, so that you can then contact their emergency contact to let them know, hey, ICE has arrived. They have detained so-and-so. They are at this location. That is information that they should give you when you request it. But again, we're not being belligerent. We're not being disrespectful. We're simply asking, where are you taking them if they are detaining someone and taking them off site? And with that, that's just a really brief primer on ICE raids. Emily and I could do a 2-hour presentation, but we wanted to set the stage as to the difference between an ICE raid and a notice of inspection, which Emily is now going to go into detail on, and that's what the rest of our presentation will be on.
Thanks, Tawny. So yeah, looking at the next slide here, this is the notice of inspection that you would get prior to an I-9 audit. So you're going to see it looks different than the subpoenas and the warrants. It takes the form of a letter. And basically what this letter says, and I know it's a little small and kind of blurry, but it is just setting forth employer obligations under the Immigration Control and Reform Act. It advises that there is going to be an audit conducted, and then down the bottom of the letter, there is an area where they say, for the employer to fill out if you so wish, I wish to waive the 3-day notice to which I am entitled to by regulation. As I mentioned before, you're entitled to 3 days of notice before they show up to inspect your I-9 forms. I personally can't really think of a situation where I would want to waive that notice, although, certainly maybe there's scheduling concerns or something like that, but I would caution that you might need that time to really prepare to make sure that when the investigator comes, it's a efficient and kind of well thought out use of their time so that you don't end up, dealing with that situation for longer than you have to. If we can flip to the next slide, please. So before we dive into what the I-9 audit is going to look like, and then specifically what the I-9 looks like, let's just talk briefly about what our obligations are as employers as it relates to the Form I-9. So first of all, employers have several obligations. So employers have to verify the identity and employment authorization of each person hired after November 6, 1986. That's per the law. And then we also have to complete and retain the Form I-9 for each employee required to complete the form. We also have several things that we are not allowed to do. So we cannot discriminate against individuals on the basis of national origin, citizenship, or immigration status. We also can't request more or different documents than are required to verify employment eligibility. Um, this is important, and we'll kind of get into this more when we go through the form, but we're just looking for identity and work authorization. And there are several different ways that employees can prove those to us, and we do not ask for more or different documents than what they provide. Similarly, if you are provided by an employee with genuine looking documents, you can't say, oh, I don't take birth certificates, I only take, passports or what have you. We have to look at the documents that employees present. We can't retaliate against or intimidate individuals who are filing charges with the Department of Justice Immigrants and Employee Rights section, who are cooperating with an investigation pursuant to that section of the DOJ, or contest any action that may constitute unfair documentary practices or discrimination based on citizenship or immigration status. And then we can't hire, recruit for a fee, or refer for a fee individuals that we know to be unauthorized to work in the United States. Next slide, please. So how does the I-9 audit process get started? So I-9 compliance is enforced by ICE, but any DHS agent acting under subpoena power can inspect an employer's I-9 forms. So, ICE can really issue that notice of inspection for any reason. It could just be totally random. You just, got picked in some way and they're coming to audit your forms. It could be initiated by a complaint that came to their office, their own initiative, or a referral from another government agency. So, how would that kind of come about? That could be, say you get charged in like a state EEOC forum, so like the MHRC or MCAT or what have you. And perhaps through the course of that process, there's something that leads that investigator to believe that an I-9 might not be completed correctly or work authorization may not be correct. They could theoretically make a referral to ICE or DHS to have them conduct their own investigation pursuant to that suspicion. As I mentioned before, you have to be provided with those 3 days of business days notice if they're looking to inspect the Form I-9s. And then when you do get that notice of inspection, it's going to identify where they believe you keep your I-9s. And this is important because if you have multiple locations and you see that the address is not reflective of where those forms are stored, you're going to want to advise the investigator that the forms are actually kept in this other location so that when the day and time comes, they go to the right place. Next slide, please. So what's the scope of the I-9 inspection? So ICE is going to check to make sure that the Form I-9 exists for every employee hired after that November 1986 date. The forms were timely and properly completed. That's to be done within 3 days of hire, and we'll get into that when we get into the Form I-9 review. Whether the documents presented by the employees were authentic. They're also going to look to whether employers participate in E-Verify. We're going to get more into E-Verify on a subsequent slide, but basically E-Verify is a free system that employers can use as an extra check for the validity of the documents that you're presented with during this process. And it can be a very helpful tool for employers to have and to utilize. And finally, ICE and DHS are going to look at how the employer handles Social Security no-match letters and the employees identified in those letters. Alongside that, if an employer learns that there's been a mistake when completing the I-9, what are your processes? What are your practices to remedy that issue? Next slide, please. Okay, so now we are going to dive into the Form I-9 itself. So this is a screenshot of Section 1 of that form. Section 1 is completed by the employee. So you're going to see the identifying fields like last name, first name, middle initial, etc. You're also going to see other fields like date of birth, social security number, and so on. So even though this section is completed by the employer is not completing this at all, we as the employer want to encourage what I would call full responses to each of these fields. So for example, you'll see the field other last names used, if any. That for some employees, the answer to that might be I've never used another last name. Instead of leaving that field blank, what we want to do is have the employee write out NA for not applicable. And this is really going to seem at times to be very like small details and like a little like nitpicky, but it is very important to make it clear to the investigator that the form has been fully completed. You'll also see for date of birth, we want to always see 8 numbers as required by the form. So for example, if an employee was born in February, they want to make sure that they're putting in 02 instead of just 2 dash so they get to those full 8 numbers. The field for email address, employees do not need to provide an email address if they don't want to, but they need to write something there if they choose to not, such as N/A for not applicable. Next slide, please. So this is a zoomed in screenshot of the remainder of section 1. And so you're going to see here that the question is posed. Check one of the following boxes to attest to your citizenship or immigration status. Here, the employee has 4 options with which they can identify. And it's important to note here, and this can get a little confusing because now after this, we're going to jump into section 2, right? But for this section, we can't request to see the documents that substantiate this choice. So the way that I would explain this, by way of example would be, let's say we have an employee who checks box 4. Box 4 requires the employee to provide a US CISA number or a foreign passport number, et cetera. And let's say the employee checks box 4 and they write in a foreign passport number in the country of issuance. We as the employer can't say, I need to see a copy of that passport right now. We're going to wait until section 2 when that employee presents us with documents, and they could give you documents that are not reflective of the document that they cited in that first section 1. So that gets a little confusing, but the way I would think about it is when we're in section 2, we are just looking at the documents that are required and we're filling out the form, only looking at those documents, and what was answered before isn't really relevant to our analysis in that section. It's also important to note that this form should be signed by the employee when they're with HR. And if they are using a preparer or a translator certification, that should also be signed that first day of employment. It's not something that the employee should be providing before they are, working with us and completing the form with HR.
So just to note on kind of what Emily just mentioned, in a lot of situations, we're going to talk about how to internally audit your own practices, and you can do that yourself. You can bring in HR consultants to do it. If you know you're going to have a lot of issues, engaging counsel to participate in the process also likely makes sense. One of the biggest areas that we see missed all the time, especially in older I-9 forms, is this preparer translator certification. While in the most recent version of the I-9 form, it's easier to see, it previously required you to say yes or no. I did use a translator, I didn't. And oftentimes it was left blank, and that would be an error or omission in the I-9 itself that for those of your employees who were hired prior to the most recent I-9 being instituted, you're going to want to be very careful kind of in reviewing, because that's often a place where we see errors. So back to you, Emily.
Thank you, Tawny. So if we flip to the next slide, let's just, before we dig into section 2, let's talk through just some quick guidance for documents, because as you know, in section 2, we're going to be evaluating documents against the USCIS guidelines. So here, if you go to the website and you download the Form I-9, it's also going to be included with that, the list of acceptable documents. And, I think we're going to talk about best practices at the end, but it can be really helpful to, obviously, you should have this with you while you do it, just to make sure that the documents that are presented to you are effective and efficient under the rules and will validate the work authorization and identity fully. So, generally, what we're going to look for all employees, without getting into specific documents, is employees are either going to present a document from List A, which validates both identity and employment authorization, or they're going to present two documents, one from List B and one from List C. So that's important to note that you either need one from List A or one from B and one from C. Sometimes we get the question, you know, hey, like an employee came in, they brought in, 5 documents and, they gave me all of them and, I'm just going to write them all down. You don't need to do that. You just want to take whatever will validate, their identity and work authorization. We don't need to kind of go over, as we talked about in the beginning, about what our obligations are. I'd also like to note here too, as you're getting documents, perhaps there's a document presented that you're not familiar with. Here, I would say, Google is your friend just to get a sense of, what that document is supposed to look like. So you kind of know, okay, like, this feels right to me if it's something that you don't see all the time. It might not always give you exactly what you're looking for, but it can point you in the right direction. So if it's something you're not familiar with, you'll get some familiarity. Next slide, please. So some general rules for documents, and I would also say that the website has a lot of information that can be quite helpful as it relates to different documents and what's required. But all documents that have an expiration date have to be unexpired. Documents that are extended by the issuing authority are considered unexpired. So that's important to note as well. And as mentioned before, employees need to present one selection from List A or two documents, one from List B, one from List C. And with that, we will turn it over to Tawny to talk about Section 2.
So Section 2, which Emily just, began discussion about, is where the employer is going to be looking at the documents itself that verify either identity or right to work in the United States. Now, you can use either a document that's listed in List A on the form provided by UCIS, or it can be a document from List B and from List C. I've had questions recently, which is, Tawny, can I just complete List A, B, and C? And my answer to that is no, it's A or B and C. While I know that in HR, oftentimes our first thought is more information is better, it's not better in all cases, and this would be one of them. We have an obligation to just do one if it's in List A or two if it's List B and C. And if you're requiring one from each, it's going to be viewed potentially as discriminatory, or if you're requiring it of some employees but not others, it's going to raise additional red flags should ICE come in and audit your practices more generally. Section 2 of this form has to be completed within 3 days of the start of employment. However, it's our recommendation that it's completed on the first date of employment, similar to Section 1. The reason for that is because we have had multiple situations where an individual comes to work on the first day of work and then decides, nope, this job isn't for me, and doesn't return. In that situation, we then have a completed Section 1, no completed Section 2, and we're going to have to write a memo to file that explains why Section 2 was never completed. This isn't a document you can just throw away to say, like, nope, they are no longer employed with us, so no worry, right? Another situation that we've had is someone arrives, and specifically in the last couple of years, we see it more and more. They come into work for day one and they start work, and then they get sick. They have COVID or something else that takes them out of work for days 3, 4, 5, for a more extended period of time, resulting in an inability to work with the employee to get Section 2 completed within 3 days of the start of employment. If you complete Section 2 more than 3 days after the start of employment, you're going to have to do a memo to the file that explains all of this background information as to why Section 2 was not timely completed. You're not going to be able to backdate your authorization or review of these documents. Again, if there's no expiration date, we recommend that you put an NA here so that it's very clear that the person who is reviewing all of these documents has looked to make sure. The other reason why putting NA if there's no expiration date is important is because simultaneously, pursuant to your HR standard operating procedures, you are likely going to want to have a chart, an Excel, sheet or some other form that is saying, hey, there's certain documents that are going to expire. Do we need to re-verify employment eligibility, right? And those are only for the forms that are directly related to employment eligibility. So not your List A documents, which verify citizenship and eligibility, but just the eligibility forms themselves. So having a chart as to when re-verification will need to occur is really important. And we're going to talk about re-verification shortly in section 3. But let's continue with section 2 on the next slide. So section 2, again, it's important that we are not using abbreviations, right? That we're writing out fully and completely the name of the organization, similar to how we were completing, document names or titles, that we are using the full title of it unless we have gone to the instruction manual for completing I-9s and we've viewed appendix, I think it's appendix A, which lists abbreviations that are appropriately used in completing the I-9. We need to make sure that the first date of employment is the hire date, the first date that they started working, and then we're going to put in today's date, as in the date in which the HR representative or the manager is reviewing the documents at issue. If this is 3 years later, it's 3 years later, right? But you cannot backdate this to be 3 days within that first date of employment. You're going to want to make sure that you've got last name, first name, and title here, and then the signature of the employer representative, so the individual from HR in most situations, with the full address here. This is really important, and it's another place where we often see blanks that it has not been completed. Instead, the individual who represents the organization has taken the 2 documents, they've made photocopies, they've put the photocopies into the file, and then either haven't completed section 2 or they've left a good amount of it blank. There is no reason for any of the data that's here in section 2 to ever be blank or NA. All of it should be completed fully, again, with 8 digits again. As a question, can you put their first day of work as the day that they meet with HR? No, it would be whatever their first date of employment actually is. That would be kind of what their first date of employment is, not their date that they meet with HR. Next slide. So we had discussed section 3 concerning re-verification and rehires. So this happens if we have documentation that has expired or if we are rehiring an individual within 3 years, 3 years of their termination or separation date with us. If we are rehiring them, we can choose whether or not to do a whole new I-9 document or simply do the rehire form of the document in section 3, which we'll look at in a moment. Or we can do the re-verification, excuse me, or if we rehire someone, we can either do a whole new sheet or do supplement B, which was previously in section 3 and now is called supplement B. As it relates to re-verification, these are going to be your employees who had documents that expired during the course of their employment. So if somebody's authorization to work in the United States has an expiration date associated with it, you are going to want to create, some type of file in which you're going to check in with the employee a few months before that expiration. And you're going to say, hey, your forms are going to expire on X, Y, and Z date. I just want to make sure that's on your radar and you've taken steps to update those documents, right? And then as it gets closer, you would ask for the updated documents. You have to have updated documents prior to the expiration date of those old documents. It could be that you have a letter um, from the federal government that indicates the status of the application itself, that new documents haven't been issued, but there will be some communication from the federal government concerning authorization to continue to work in the United States. Let's go to the next slide. So here, this is the re-verification and rehire section. It looks different depending on what year the individual was hired. So this is the most recent re-verification and rehire section that is now called, I apologize because they keep changing the location, Supplement B, but previously was known as Section 3. You're going to want to make sure that you have the employee's full name, last name, first name, and middle initial. And then if it's a rehire, you'll have the rehire date. And if there's new names or a change of name in any way, then you'll complete there, right? In most situations, it's helpful to just put the person's whole name there again. There's nothing wrong with just repeating the information from above, even if it's not new. For the re-verification, you're then going to do that document title, document number, and expiration date. This is only if it's a re-verification. If it's a rehire, then you don't need to because you still have document A, B, or C. If it's a rehire and the documents that have previously been provided have expired, however, then you're going to have to do the re-verification element as well. And then finally, you're going to do your full name, your signature, and the date. In most situations, there's not going to be any additional information unless you're using an alternative procedure. And then you're going to check that box to identify kind of what process you used. Go to that next slide. Additionally, one of the questions we're getting a lot on lately is E-Verify and whether or not this is something that insulates an organization from liability if there were issues or if they were, in fact, employing an undocumented individual. First, use of E-Verify does not replace Form I-9. So you can use E-Verify, but you still have to have that Form I-9. It is a free piece of software, and what it does is it checks into information that's included on the employee's Form I-9 with records from DHHS and Social Security to confirm work eligibility. It can be a useful tool, but you have to be mindful of deadlines for completing I-9 paperwork more generally. One of the questions that we've been getting more recently is, hey, we're going to start using E-Verify. Should we go back and put everyone's name and information into it and see if there's issues? One of the questions or issues becomes is what are you going to do if it shows that they don't, that E-Verify says that there's an issue and that there's not a match? And lately, a lot of people are saying, well, we're not going to do anything. And if you're not going to do anything, then no, I wouldn't keep putting people into E-Verify. The other question we've gotten a lot of is, should we run E-Verify at the same time that we're completing the paperwork, or can we just do E-Verify once every 6 months or once every 12 months? And the answer is very similar. What value does the use of E-Verify have for the organization if they're using it significantly after the individual has already begun employment? These are individualized questions for an organization, both from an operational perspective, how much time and energy does it take? Do you have the bandwidth to do it? But more so, it goes back to that, thing that I've already stated once today, more information is not always better information, right? So if you're going to use E-Verify to truly recognize, do we have any issues with the data that's being provided by this employee, or not, that's fine. But if you're just doing it to kind of check a box, then it's more problematic. I mean, just for examples, we've had multiple circumstances and situations where we have clients who use E-Verify, come to find out they were employing someone who was undocumented, and it didn't pick up on it. So it's not foolproof in a number of ways, and ICE isn't going, DHS or ICE isn't going to look at it and say, no, you used E-Verify, and thus, you have no liability generally. There is a chance that we see a shift or a change in which individuals are required to start using E-Verify, and that'll be different. And I know for some state contracts, it's already required, so you might start seeing different contractual obligations there. But right now, it is not a requirement. It is a choice that employers are free to make. Let's go to the next slide. So if I-9 comes, they do an inspection, they look through all of your documents, what happens next, right? So I-9 inspection dispositions take a number of different forms. So you'll get a notice of the results, and it will include different things that you need to do in order to become compliant if you're currently out of compliance. It's going to list if they believe that there's suspect documents or if there's discrepancies within your documents. If there's notice of technical or procedural failings or warning notice or a notice of intent to fine the organization. As it relates to notice of discrepancies, this goes to oftentimes employers will take photocopies of Section 2 documents. That is permissible. It is not required. You're not required to have photocopies of the documentation that was provided in verifying identity or eligibility to work in the United States. Most employers believe that it is helpful and it likely is best practices, but you need to do it across the board. So you can't pick and choose, hey, I have copies for some people, but I don't have copies for others, because that could be seen as discriminatory. I only request copies of people who have brown skin, but not people who have white skin, right? That would be a discriminatory purpose. But in that notice of discrepancies, what they're going to be doing is looking at the documents that were provided by the employee and then looking at what's included in that Section 2 to determine whether or not the data is the same. So then a lot of employers will say, well, shouldn't I just not request copies? You can do that. What it does is it creates issues as you're auditing, right? As you do internal audits, it's hard to determine whether or not you have issues or discrepancies more generally because there's not a document to look at. And you cannot go back to employees and request that they provide a copy of the document that they've previously provided to you. Let's go to the next slide. So consequences. So there's civil, if you were to have a civil violation, right? The fines, the old fine amount, this was the 2024 fine amount, the new fine, 2025 fines for this year. So you'll see different amounts, and they go into different groupings, right? If you have document fraud and it's your first time versus if you have multiple issues with document fraud. If you are knowingly employing undocumented individuals versus, you weren't knowingly and you just have either I-9 violations or you had some type of fraud order. So the numbers that are listed here are per violation, right? So keep that in mind when we talk about per violation. Oftentimes we get to a maximum fine on these documents, right? Because if you have 5 or 6 violations on one form, so per employee, potentially looking at $2,800 per employee, the fines can get up there. So it's important to understand that these aren't kind of slap on the wrist type fines, that they can be substantial. Let's go to the criminal. So there are criminal consequences as well if you knowingly engage in a pattern or practice of hiring or employing unauthorized non-citizens. It's important to recognize that one of the places where ICE has really been coming down on this recently has been as it relates to working with third parties. So if you do use outside agencies, employment agencies or anything like that, even if your contract says, hey, you're responsible for I-9 compliance, if they're working for you, we're going to see the administrative agencies go after kind of the organization in which the work was being performed for. So is there a chance that the employer agency also has exposure? Yes, but you need to recognize that if you are attempting to get around I-9 requirements by using independent contractors or using a staffing agency, that you're still looking at both civil and potential criminal um, consequences as a result of kind of those activities more generally. Let's jump to some operational concerns that you likely will have.
Yeah, so it just kind of jumping on Tawny's point about civil and criminal penalties. There is certainly operational costs to compliance as well. So, certainly the cost of the time spent in the audit, remedying any findings, general interference with work and operations, and the possible loss of, people in your workforce if it's ultimately found that they don't have work authorization. If you're a federal contractor, you could be debarred from future contracts. We have a little asterisk there just because there's been so much chatter about, federal contractors and their obligations to the government. But as of today, that is, a possible outcome if, we're not compliant with the process. Next slide, please. So some best practices to take into consideration when you're completing the I-9 thoroughly and correctly. So we want to make sure that we have, complete information and we can include the correct information. So we should really make sure that we're taking our time and reviewing the documents closely while we complete that form. Similar to what Tawny mentioned in terms of identifying a point of contact for ICE raids, I would recommend the same thing here as it relates to I-9 compliance. Having a manager, oversee the process and then also conduct internal audits of the documents to make sure that they are appropriately completed is really important. And we'll talk about audits here in the next slide. But also training and retraining employees who are responsible for completing the I-9 documents to make sure that those are being completed consistently. I would, highly recommend creating a bunch of standard operating procedures about how to complete the document. If you're making copies of identification, doing that in the same way. And then if using E-Verify, having standard work instructions available to the employees that are utilizing those systems. And as Tawny suggested in section 2, having a template or a calendar tracker so that when you have to follow up with employees as to getting renewed work authorization should they have documents that are expiring over the course of employment. So keeping all of that in mind, if we flip to the next slide, we did want to highlight briefly, what happens if you're doing an audit and you realize, oh, there was a mistake that was made on this form, which can happen. And, even though we have best practices and we, have standard operating procedures and we try our best to make sure everything's correct the first time, something might come up and we realize as we're reviewing that there was an issue. So, what's tricky about this is that the government is very particular about how possible revisions are made. So there's a bunch of guidance on the website that I would highly recommend you take a look at if you are in the process of, initiating an audit before you start making changes. But generally, if there's one error, so say here we have the example, the employee didn't write their last name correctly. You will draw a line through the incorrect information, enter the correct information, and initial and date the correction. this is like a fairly simple one to update. We would also recommend, when we're talking multiple errors, we're going to talk about a memorandum here in a second. I would also recommend that you attach a note to the back of that I-9, just saying, hey, on this date, we made this change, or, the staff member that made the change, identify themselves and identify the date and why you made the change. In this case, it would be the last name was written incorrectly. If there are multiple errors on the form, you may need to redo that whole section on a new Form I-9 and attach that to the back of the original I-9. If it's just going to be like, a total disaster by the time you strike all of these things. In that case, you're also going to attach a memo to the original I-9 explaining why you made that change along with the new I-9 that just has that section completed. And those notes in the file are going to be really helpful if you do get audited so that the investigator understands why the changes were made, even if it seems self-explanatory from what the changes are. What's really important that we don't do when we make changes is not using like whiteout or, doing like a crazy like cross out instead of just the simple one line. We just really want to make sure that it doesn't look like we're trying to conceal information because ICE or DHS could take that as willful concealment or something of that nature. Similarly, you'll note that we're supposed to keep the original I-9, so we're not throwing out the original I-9, even if the new I-9 has many changes and looks quite different. But those are the guidelines for how you would do an audit. And I would also highly recommend that you check out the website as well before you start that process. They have a lot of really great resources on common mistakes that they see. And that can be really helpful in where to direct you as you do your audit. And I think with that, we have a few minutes left for questions.
Yeah, so some of the questions. One of them is if someone supplies you a state ID or a driver's license and a social security card, but the social security card contains a restriction. If the restriction says not valid for employment or valid for work only with DHS authorization, you're going to have to look to see if it's going to fit within what is needed, right? So if it's a list A, B, or C, what have they provided you with? In most situations, it's not going to be sufficient for work authorization, so you'll need a different document. But unfortunately, in part, this depends on kind of the other documents that are being provided as to the necessity or whether or not it can appropriately be used. Another question we got was concerning the statement that we made earlier, which is that Section 1 needs to be completed on the first day of work. Under the guidance in USCIS, it states that it can be completed beforehand, right? Which is correct, except that by having employees complete it beforehand, you arguably are running into a wage and hour issue, right? Having employees complete documentation before they arrive at work, review employee handbooks, review policies, any of those type of things, the onboarding documents, an argument can be made that that is compensable time, right? And it creates then wage and hour exposure. So you can have them do it beforehand with the understanding that there's potential wage and hour exposure for something along those lines. So when somebody changes their name legally, right, we're going to need to go through the audit process that Emily previously set forth, right? If it's to Section 1, the employee is going to draw the line through it, right? And they're going to put their initials and they're going to put their new name. We're going to take copies and we're going to add that to the process itself. We are never going to complete Section 1. So if Section 1 has changed, right, we need the employee to come in and recomplete it. Another way and it gets messy sometimes, the document itself. In some situations, you could do a full memo that attaches to the old one and includes a new I-9 with it that has the updated information. That memo itself has to be extremely detailed about there's been a name change, this is the reason, this is kind of all of those, that information more generally. In most situations, however, the name change in and of itself shouldn't result in change in authorization to work or identity. So you should just be able to have the employee cross out whatever the change is and identify it, and then for you to be able to put it in to the memo. We have, and I apologize, a ton more questions. I think what we're going to do is we will put together an alert or blog post that we'll get out that kind of goes to these questions more generally, because we do want to be mindful of everyone's time. So we very much appreciate everyone's time and attention here. Please keep your eyes posted for a blog post that will kind of set forth answers to many of all of these questions. And thank you so much and have a great rest of your day.